Federal Judge Scenes delivered a striking admonition to the Department of Justice this week in the ongoing Kilmargo Garcia case, signalling a profound shift in judicial tolerance for executive non-compliance. Over the past several weeks, Judge Scenes has presided over repeated attempts by DOJ counsel to shield documents and testimony behind broad assertions of privilege. In an 8-page order issued today, she declared unequivocally that such tactics end now, documenting that if a week's defendants have sought refuge behind vague and unsubstantiated assertions of privilege, using them as a shield to obstruct discovery and evade compliance with this court's orders. The decision underscores the judges finding that the Trump administration's lawyers continued to rely on a boilerplate assertions, even after the court's explicit requirement for a specific legal and factual showings to support any claim of privilege. In starker terms, Judge Scenes concluded that DOJ counsel advanced to falsehoods and engaged in a willful bad faither across several contexts, findings that sit at the highest end of judicial reproach. Such pointed findings are extremely rare in federal litigation. In more than 30 years as a federal prosecutor, legal observers note it is virtually unprecedented for a judge to brand government attorneys as having committed ethical violations so plainly. To see a sitting judge not only denounce counsel's conduct, but also flag it as potential career-ending misconduct marks a significant departure from the norm of judicial restraint. At the heart of this dispute lies the court's order requiring the Department of Justice to facilitate the release of Abrago Garcia, identified as Kilmargo Garcia in initial filings, and to arrange his secure return to the United States. The judge's mandate, which the Supreme Court affirmed, directed that Mr. Garcia's matter proceed as though he had never been deported unlawfully to El Salvador. Yet, despite both the Supreme Court's and this court's clear instructions, the federal government declined to comply. In response, Judge Scenes established a sharply truncated discovery period. Under that schedule, counsel for Mr. Garcia may demand depositions of DOJ employees, propound sworn statements, and submit document production requests. The government is obliged to produce the specified records and secure appearances. All of this is expressly designed to determine whether the DOJ lawyers should face contempt, civil or, potentially, criminal, for deliberately defying the court's orders. Among the many instances of misrepresentation catalogued in the order, Judge Scenes highlighted one particularly telling example: the DOJ's assertion that there was no directive to release Abrago Garcia. The order flatly rejects that contention, noting that the judge herself issued the release order and that the Supreme Court later affirmed it. Those misrepresentations, she warned, could amount to the death knell for the responsible attorneys' careers. The potential professional consequences extend beyond the bounds of the Department of Justice. Federal attorneys must maintain an active state bar license. Unethical conduct in court may lead to referrals to state bar counsel and full disciplinary investigations. Sanctions can range from censure to disbarment. Observers point to the disbarment proceedings against former New York Mayor Rudy Giuliani, who lost his licenses in New York and the District of Columbia for his role in post-2020 election challenges, as a stark example of how judicial findings of misconduct can have career-ending effects. Within the Department of Justice, however, immediate professional repercussions appear unlikely. The DOJ remains under the leadership of Pam Bondi, whose tenure has been marked by a reported willingness to subordinate established norms of prosecutorial independence to political considerations. As such, lawyers who act in ways deemed unethical by an impartial court may find departmental immunity in the short term, yet this protection does not extend to their state bar credentials. Moreover, many of these attorneys operate with the perceived security of proximity to presidential authority. Insiders suggest that the shield of being in the inner orbit of the administration reduces immediate fear of discipline, creating a dangerous dynamic in which political loyalty overrides the oath that federal prosecutors swear to uphold the Constitution rather than any individual official. This dynamic raises concerns about the long-term integrity of the Justice Department's legal function. State bar associations, for their part, have moved toward more proactive enforcement. A growing number employ dedicated software to continuously scan court transcripts and published opinions for language indicating that an attorney acted unethically. When a judge records that an attorney has misled the court or engaged in bad faith, that software triggers automated alerts, prompting the bar to initiate an investigation. Such systems aim to catch misconduct in real time rather than rely solely on external complaints. As for the Kilmargo Garcia case itself, the discovery clock continues to tick. Judge Scenes allotted 2 weeks for the Garcia team to assemble evidence of executive non-compliance. Approximately 1 week remains in that period. So, within days, the parties are likely to return to court to resolve further discovery disputes. Ultimately, the judge must decide whether to launch formal contempt proceedings against the DOJ lawyers, an action that could carry both civil penalties and even criminal sanctions for willful obstruction of the judicial process. The fallout from these developments will extend well beyond Mr. Garcia's fate. Should the court impose sanctions, the reputational damage and potential disbarment could reverberate through the Justice Department. At a pivotal moment in American jurisprudence, Judge Scenes' firm stance may serve as a reminder that even the highest levels of government remain subject to the rule of law. Beyond the immediate procedural skirmishes, the Kilmargo Garcia matter evokes historical parallels that underscore the enduring tension between branches of government. In the early 19th century, federal courts confronted the executive branch's attempts to override judicial mandates in cases such as Worcester v. Georgia, where President Andrew Jackson was famously, though apocryphally, said to have defied Chief Justice Marshall's decision. More recently, themes of executive non-compliance surfaced during the Watergate era, when the Nixon administration resisted disclosures under congressional subpoenas and court orders, culminating in a landmark Supreme Court decision affirming that no person, not even the President of the United States, is above the law. Judge Scenes' ruling thus continues a long arc of American jurisprudence, demanding that executive power bow to the authority of the judiciary when constitutional rights hang in the balance. At its core, the case tests the separation of powers in our constitutional system by refusing to carry out a judicial mandate endorsed by the Supreme Court, namely, the release and repatriation of Abrego Garcia. The Department of Justice undercuts the judiciary's capacity to enforce the law impartially. Judges possess the authority to compel compliance through contempt powers, yet the real-world efficacy of those powers depends on the executive branch's willingness to respect the rule of law. Should the DOJ attorney successfully evade serious consequences, it would signal to other federal officials that judicial orders may be flouted with impunity, thereby eroding public confidence in the courts. Congressional oversight is likely to enter the fray in the coming weeks. Members of both chambers have already signaled interest in examining whether the executive branch has abused its investigatory and prosecutorial prerogatives. Legislative proposals under discussion include mandates for the DOJ to produce regular reports on court compliance and to establish an independent Inspector General's office, tasked with auditing instances of alleged judiciary defiance. Such measures would aim to reinforce accountability and ensure that future administrations cannot treat court injunctions as optional suggestions. Within the legal profession, authoritative voices have begun to weigh in. The American Bar Association's leadership has expressed concern that political considerations appear to be displacing the ethical obligations that every attorney swears to uphold. Several state bar committees are reportedly convening emergency sessions to review the judge's 8-page opinion and to discuss whether expedited disciplinary rules should apply when government lawyers face findings of a willful bad faith. Leading law firms, meanwhile, are revisiting internal policies to ensure that any staff or partners called to public service are prepared to navigate the heightened risk of professional sanction should they choose to align too closely with overtly political directives. On the international stage, allies and adversaries alike are watching closely. Democracies in Europe and beyond have cited the Garcia litigation as a litmus test for the resilience of American legal institutions. Authoritarian regimes, in contrast, may point to the dispute as justification for their own claims that courts are subservient to political leadership. Human rights observers at the United Nations have already cited the case in reports on due process guarantees, highlighting how the fate of one individual, Abrago Garcia, can reveal much about a nation's commitment to its foundational principles. As the discovery period draws to a close and the spectre of contempt proceedings looms, this litigation will set a precedent with far-reaching implications. If the judiciary's contempt powers prove effective, they will reaffirm the indispensability of an independent legal system. But if the Department of Justice continues to flout court orders with little tangible fallout for its attorneys, the balance of power may shift decisively toward the executive, leaving the judiciary's authority in question. In the weeks ahead, the court's capacity to enforce compliance and the legal community's resolve to uphold ethical norms will determine whether the United States maintains its standing as a nation governed by law rather than by the whims of those in power.